In Episode 1, we alerted the public and potential victims to an alleged major underground fraud scheme that, according to evidence, continues in Riverside County. We warned that the allegations point to a scheme far more serious than fraud being uncovered in other California counties and programs, including counterfeit court authority, falsified judicial records, manufactured legal consent, and a public funding machinery allegedly operating behind the appearance of routine government procedure. Episode 1 introduced the legal engine, the alleged municipal corruption, how the operation expands, and how members of the public become its targets. It showed how missing advisements become illegitimate consent, how illegitimate consent becomes falsified court records, how falsified court records can produce defective jurisdiction, how defective jurisdiction can produce void orders, how void orders become enforcement in excess of constitutional authority, how enforcement under color of law becomes mass public harm, and how, when government bad actors knowingly and systematically impose that expanding harm to obtain ill-gotten benefits, control, leverage for retaliation, institutional growth, political influence, and taxpayer-funded enrichment, the allegation is no longer just misconduct. It is an unlawful enterprise. This is Episode 2, Criminal Syndicate Uncovered. Some corruption scandals begin with cash in envelopes. Others begin with a misrepresentation entered in a legal record, a fabricated court entry, a false account in a minute order, a line in the record that says you agreed, a recital of an event asserting you waived your rights, a fabricated legal instrument that turns defective authority into an enforceable order. Once that paper exists, agencies can rely on it, sheriffs can enforce it, money can move, families can be disrupted, liberty can be restricted, and the public can be told the process was lawful. That is the heart of the Riverside County allegation. Not simply one bad ruling, not simply one mistaken clerk entry, not simply one litigant unhappy with a court result, but a repeatable court and enforcement apparatus allegedly built around defective authority, misleading records, downstream enforcement, public funding benefit, and retaliation against those who object. The allegations, if substantiated, could place Riverside County in the same historical category as some of America's most notorious government corruption syndicates. Not because the facts are identical, but because the alleged method is familiar. Official authority and justice are used as the mask. Records become the weapon. Public institutions become the machinery, and the public is told it is all lawful. A criminal syndicate is not limited to a mafia family, cartel, or underground gang. In public corruption terms, it can describe a continuing association of officials, employees, private actors, attorneys, enforcers, administrators, agencies, and institutional beneficiaries who coordinate their roles to carry out unlawful objectives for financial, institutional, political, material, or coercive benefit. Federal RICO case law recognizes that an enterprise does not need a formal name, rigid hierarchy, or traditional underworld structure. In United States v. Predicate, decided in 1981, the United States Supreme Court recognized that RICO can apply to illegitimate enterprises. In Boyle v. United States, decided in 2009, the court confirmed that an association in fact enterprise may be shown through purpose, relationships, and continuity, not formal titles or written rules. That matters here because different actors may serve different functions. One actor may create the record, another may transmit it, another may rely on it, another may enforce it, another may protect it, another may benefit from it. That is why the word syndicate matters. It describes the whole machine, not just one person, not just one courtroom, not just one criminal statute. Consider two of the most notorious exposed government syndicate scandals in American history. The Tweed Ring in 19th century New York was not simply one corrupt politician taking bribes. It was a political, judicial, financial, and contracting machine. Public offices, city contracts, judges, courts, invoices, contractors, and political power all became parts of the same corrupt structure. The Teapot Dome scandal later proved the same lesson at the federal level. Cabinet authority, official leases, and formal government paperwork did not prevent bribery and betrayal of the public trust. The lesson is simple. A government syndicate does not stop being a syndicate because it involves government actors or uses official buildings, courtrooms, records, badges, public offices, or government paperwork. Those individuals and tools may be exactly what make the enterprise work. Now consider the Riverside County allegations. The alleged exploitation point centers on temporary judge and commissioner authority. Under the California Constitution, Article 6, Section 21, a temporary judge may act only on stipulation of the party's litigant. Put simply, a temporary judge gets judge-like authority only because the parties knowingly agree to allow that person to act as the judge in that case. Without valid litigant stipulation, the constitutional authority for that temporary judge is never lawfully created. Under the California Constitution, Article 6, Section 22, the legislature may provide for the appointment of court commissioners and other subordinate judicial officers, and may authorize them to perform subordinate judicial duties. Put simply, a commissioner is a subordinate judicial officer created to assist the court. A commissioner is not the same thing as a judge. A commissioner may perform subordinate judicial duties authorized by law, but that is not the same as becoming a judge with full, final decision-making authority over a litigant's case. Even when a commissioner wears a robe, sits on the bench, and conducts a hearing, that does not automatically give the commissioner full judge power. For a commissioner to exercise that kind of final, temporary judge authority, the commissioner must be acting in a separate legal capacity as an appointed temporary judge, commonly called a judge pro tempore or judge pro tem. And that only works if the litigants were first properly advised of their rights and then gave valid consent. Temporary judge power still requires the separate constitutional gateway, valid stipulation under Article 6, Section 21. For a commissioner to exercise that kind of final temporary judge authority, the commissioner must be acting in a separate legal capacity as an appointed temporary judge, under Article 6, Section 21, through valid litigant consent. And that only works if the litigants were first properly advised of their rights and then gave valid stipulation. California Code of Civil Procedure, Section 259, Subdivision D, follows the same constitutional structure. A commissioner may act as a temporary judge only when qualified, appointed for that purpose, and acting on stipulation of the parties. That distinction is critical. If a court record says the parties stipulated to commissioner, that does not necessarily mean the parties stipulated to a temporary judge. Those are not the same thing. A commissioner is one legal status. A temporary judge is another legal status. A commissioner may already be assigned by the court. The litigant's consent is not what makes the person a commissioner. The litigant's consent is what may allow that commissioner to step into the separate role of temporary judge and exercise judge-like authority. So if the record only says stipulated to commissioner, that may be defective on its face. It may show no valid stipulation to a temporary judge at all. This is not a technical loophole. A court record cannot truthfully certify authority that was never lawfully created. In People v. Tijerina, decided in 1969, the California Supreme Court agreed that an order was void where no stipulation permitted a commissioner to act as a temporary judge. In plain terms, without valid consent, the commissioner did not have temporary judge authority. 5 years later, in Saraceno v. Superior Court, decided in 1974, the California Supreme Court again treated stipulation as the constitutional gateway to temporary judge authority. So the question is not whether the paperwork used official language. The question is whether the required consent existed before the commissioner exercised judge power. California Rules of Court, Rule 2.816, fully implemented in 2007, explains what the court must do before a valid temporary judge stipulation can be created. The court must give notice before the proceeding begins. The court must tell the parties that a temporary judge will be hearing the matter. The court must identify the temporary judge, including that the temporary judge is a qualified member of the state bar. That disclosure matters because it tells the litigant the person hearing the matter is an attorney assigned to act as a temporary judge, not an ordinary judge. And most importantly, the court must tell the litigant that they have the right to have the matter heard by a judge. That is the core issue. The litigant has a right to an actual judge, a judge whose authority does not depend on the litigant unknowingly giving permission, a judge whose authority does not depend on disputed consent, defective signage, or a minute order later claiming permission was given. This is not legal trivia. This is the constitutional pressure point. The system depends on consent, but consent is only meaningful if the person knows what they are consenting to. If a self-represented parent, tenant, defendant, or litigant is never clearly told, "You have the right to a judge," then silence cannot fairly be treated as informed permission. And if they are never told that the commissioner is acting as a temporary judge, then continued participation cannot fairly be treated as a knowing waiver. California case law confirms the importance of stipulation, but it must be understood in context. In re Horton, decided in 1991, the California Supreme Court recognized what is called tantamount stipulation. That means implied consent, or implied permission. Horton recognized that a party's conduct may, in some circumstances, amount to implied consent, when the party knows the judicial officer is a commissioner and proceeds without objection. But Horton was not a minor civil matter. It involved a commissioner presiding over a capital murder case. That is why Horton is both important and dangerous. The majority found implied consent through counsel's conduct, but Justice Mosk dissented, warning that the defendant had not been personally told he had the right to a superior court judge, and should not be bound by implied consent to a non-judge when that right was never meaningfully disclosed. That warning matters here. Horton was decided before the modern Rule 2.816 advisement framework was fully implemented in 2007. After Rule 2.816, the sequence materially changes. The court must first give the required advisements. The litigant must first be told that the temporary judge is a qualified member of the state bar. Most importantly, the litigant must first be told they have the right to a judge. Only after that can silence or failure to object be evaluated as possible deemed or implied stipulation to an appointed temporary judge. So Horton does not authorize a court to skip mandatory advisements and later manufacture consent from silence. It does not authorize a court to create jurisdiction from a litigant's confusion. And it does not mean a litigant's participation can cure a notice process that was materially defective or omitted from the beginning. Horton does not solve the Riverside County problem. Horton exposes the danger. It shows why implied consent is dangerous when litigants are not clearly told they have a right to a judge. Rule 2.816 is the later safeguard that makes the notice requirement explicit. In re Marriage of McClintock and Julis, decided in 2017, the California Court of Appeal confirmed the consequence. Without qualifying a commissioner to act as temporary judge, and without the required stipulation, any ruling or judgment by the commissioner is void. That is why this issue matters. If the authority was never lawfully established, the resulting order is not merely controversial, it may be void. And void authority has consequences. California law does not treat void authority as ordinary court error. Not every legal error makes an order void. but where the power to act was never lawfully created. The defect is different. In Baird v. Smith, decided in 1932, the California Supreme Court described a judgment void on its face as a dead limb upon the judicial tree, something that may be removed because it never had lawful life. That image matters. A void order is not merely bad fruit from a healthy tree. It is a dead branch attached to the system, creating the appearance of lawful life while carrying no lawful authority. Modern California courts have repeated the same principle. In Rochin v. Pat Johnson Manufacturing, decided in 1998, the Court of Appeal explained that even a final order has no preclusive effect if it is void. The older rule is even more direct. A void judgment is, in legal effect, no judgment. It creates no rights. It takes away no rights. And proceedings founded on it are equally defective. And in People v. American Contractors Indemnity Company, decided in 2004, the California Supreme Court confirmed that when a court lacks jurisdiction in the fundamental sense, the resulting judgment is void and vulnerable to direct or collateral attack at any time. The point is simple. Finality does not transform non-existent authority into lawful power. An official seal does not cure a defective foundation, and a court record does not become valid merely because agencies later rely on it. This matters because if temporary judge authority never lawfully existed, the problem is not merely a procedural irregularity. The defect goes to the power to act. Later reliance does not retroactively create consent. Later enforcement does not honestly create consent. And a later transfer to a judge does not automatically validate orders entered before lawful temporary judge authority existed. A later judicial officer may act going forward, but that does not rewrite what happened in the courtroom. It does not create prior consent, and it does not convert an allegedly void order into lawful authority after the fact. The litigant cannot withdraw a temporary judge stipulation that was never lawfully obtained, and the court cannot truthfully certify consent that never lawfully occurred. If officials nevertheless treat that defective record as valid, enforce it, rely on it, and continue doing so after formal notice, the issue moves beyond isolated error. It may become evidence of an intentional authority certification apparatus. According to Blacklight Advocate's Operation Emperor's New Clothes report, the alleged apparatus works through a simple but powerful loop. First, required Rule 2.816 advisements are allegedly omitted, incomplete, misleading, or materially defective. Litigants are allegedly not clearly told that the commissioner is acting as a temporary judge. They are allegedly not told the temporary judge is a member of the state bar. And most importantly, they are allegedly not told they have the right to a judge. Second, because the required advisements are missing or defective, no authentic temporary judge stipulation occurs. Third, later court records allegedly recite, imply, or preserve the appearance that due process was administered and that the parties provided the required consent. In many proceedings, the record allegedly does not clearly show that litigants knowingly stipulated to a temporary judge. Instead, the record may state something like, parties stipulate to commissioner. But a stipulation to a commissioner is not the same as a stipulation to a temporary judge. Fourth, the resulting minute order or court record is mailed, electronically transmitted, or entered into official systems. Because the required advisements were allegedly omitted, litigants may not even understand that the authority being exercised over them was defective. Fifth, when litigants challenge the deprivation of rights, their objections are allegedly blocked as waived, untimely, already decided, or procedurally improper. Sixth, the orders are treated as valid. Agencies rely on them, attorneys cite them, sheriff personnel enforce them, and downstream systems continue processing them as legitimate. That is the alleged machine. Defective notice, defective consent, misleading record, denied review, downstream enforcement, money, control, retaliation, and public funding. This is where the issue leaves the courtroom and enters the machinery of government. A defective order is not harmless when it becomes the basis for enforcement. Sheriff personnel may control courtroom access, remove individuals asserting rights, threaten arrest, and enforce contempt orders, warrants, custody transfers, restraining orders, evictions, and other post-hearing consequences. They may rely on the court record as certified authority, but after credible notice of a systemic authority certification defect, the argument is that we just enforce what the court says becomes a weaker defense if the authority being enforced was unlawfully manufactured. The reach of the alleged apparatus may not stop with ordinary family law or child support matters. The same authority defect may matter wherever commissioners or temporary judges preside over proceedings that generate final, coercive, or record-hardening consequences. In CPS, DPSS, dependency-adjacent, or family court proceedings involving agency personnel, county counsel, social workers, evaluators, or program staff, the concern is not merely later reliance on court records. These actors may participate in filings, recommendations, placement decisions, service plans, custody restrictions, visitation limits, and enforcement requests that help create, harden, or operationalize the court's output. Such outcomes are not minor administrative acts. They can affect where a child lives, what a parent must do, what accusations become embedded in the record, what services are compelled, what restrictions are imposed, and what agency actions follow. In misdemeanor, traffic, or lower-level criminal proceedings, the same concern may arise where prosecutors, public defenders, private attorneys, probation personnel, program providers, sheriff personnel, and commissioners participate in pleas, findings, probation terms, fines, custody consequences, home detention, ankle monitoring fees, mandatory programs, or punishment-related orders. Again, the issue is not whether every such proceeding is automatically defective. The issue is whether the person exercising judge-like power had lawful authority before the proceeding, plea, order, punishment, placement, service requirement, or enforcement consequence was created. If the authority depends on temporary judge consent, then the threshold questions remain the same. Was the required notice given? Was the right to a judge disclosed? Was the temporary judge properly identified? Was valid consent actually obtained? Or did the record merely preserve the appearance of consent after the fact? The same concern extends to agency systems. In child support proceedings, the Department of Child Support Services is not merely a passive observer when its attorneys and staff appear in high-volume Title IV-D matters, advocate for enforcement, oppose objections, and rely on minute orders as authoritative. If the underlying temporary judge authority is defective, and if that defect is later concealed or certified through record language, agency advocacy may become a material link in the machinery. Family Code Section 4251 adds another layer. In Title IV-D child support proceedings, parties are supposed to receive specific advisements and a pathway to judge review when they object to a commissioner acting as temporary judge. The allegation is that the machinery closes that loop. Defective advisement, defective consent, record certification, denied review, then enforcement. This is where the alleged conduct begins to look less like isolated court error and more like an enterprise. Because an enterprise is not shown only by one bad act, it is shown through apparatus, pattern, continuity, roles, benefit, knowledge, and continuation after notice. The apparatus is the repeatable process. The actors are the judicial officers, clerks, agency attorneys, sheriff personnel, municipal actors, administrative offices, and institutional beneficiaries allegedly connected to that process. The roles are record-making, record transmission, enforcement, objection suppression, funding preservation, and retaliation against exposure. The benefit may be money, fees, budgets, agency activity, political advantage, institutional protection, promotions, operational expansion, or concealment of prior misconduct. The knowledge comes from notice. Blacklight alleges that courts, presiding judges, sheriff leadership, tribunal agencies, attorneys, municipal actors, and related personnel were placed on notice through oral arguments, filings, motions, writ petitions, judicial notice requests, jurisdictional challenges, emails, certified mail, personal service, and mass-distributed cease and desist notices. Those notices allegedly identified the legal defects. They cited constitutional provisions, statutes, rules, and case law. They warned of downstream enforcement consequences. They warned of public funding implications. And they warned that continued participation could evidence intentional ignorance, reckless disregard, willful blindness, and Scienter. Scienter means knowledge, intent, willful blindness, reckless disregard. According to Blacklight, the alleged response was not emergency correction, not audit, not disclosure, not neutral investigation. The alleged response was obstruction, silence, adverse record-making, suppression of filings, denial of remedies, coercive courtroom control, sheriff-assisted intimidation, retaliation, and continued enforcement. That is the difference between a defect and a syndicate theory. Not every defective court record proves a crime. Not every commissioner error proves a syndicate. Not every deputy who enforces an order knows whether the underlying authority was defective. And not every adverse ruling is evidence of corruption. The allegation here is different. The allegation is a repeated, court-wide, post-notice pattern. Defective advisements, misleading records, blocked objections, downstream enforcement, public funding benefit, and retaliation after exposure. If substantiated, that conduct does not fit into one legal box. It potentially implicates multiple enterprise functions. The record-making function concerns false certification, document misuse, obstruction, mail or wire transmission, and records allegedly applying a person's identity to consent they never knowingly gave. The enforcement function concerns official force, threats, contempt, warrants, custody pressure, financial penalties, or sheriff-backed authority used to compel compliance. The funding function concerns fees, agency activity, Title IV-D claims, budgets, contracts, grants, or institutional expansion allegedly justified by defective proceedings. The concealment and retaliation function concerns suppression of filings, record manipulation, intimidation, whistleblower retaliation, and continued enforcement after notice. These same enterprise functions may overlap with multiple Predicate Act theories under RICO and related public corruption laws, including fraud, extortion, obstruction, retaliation, money laundering, identity document misuse, false claims, coercive enforcement, and color of law civil rights violations. The point is not that every actor committed every offense. The point is that, if proven, different actors allegedly performed different roles in one continuing machine. Court records, agency systems, enforcement personnel, mail, electronic systems, financial systems, all allegedly used to preserve, enforce, conceal, or profit from defective authority. That is why the word syndicate fits the allegation. A syndicate is the machine. The court record is the lever. The enforcement system is the force. The agencies are the pipeline. The funding is the incentive. The whistleblower retaliation is the shield. And the public is the target. This is not merely a historical complaint. If the allegations are true, current litigants, parents, tenants, defendants, juveniles, witnesses, process servers, and self-represented parties may still be entering courtrooms without knowing whether the authority being exercised over them was lawfully obtained or if it is a branch of a larger corruption system. If you appeared before a Riverside County Commissioner, temporary judge, judge pro tem, child support commissioner, family law department, traffic calendar, small claims calendar, unlawful detainer proceeding, probate proceeding, contempt hearing, criminal matter, CPS or DPSS related proceeding, or enforcement related hearing, you may need to check your record. Ask yourself, did anyone clearly advise you that a temporary judge or commissioner acting as temporary judge would hear the matter? Were you told you had the right to have the matter heard by a judge? Were you told the temporary judge was a qualified member of the state bar? Were you asked to stipulate after receiving proper notice? Did the minute order state that you stipulated only to a commissioner instead of a temporary judge? Did the minute order imply that you stipulated, even though you never knowingly agreed? Were objections treated as waived or untimely? Did DCSS, DPSS, sheriff personnel, clerks, attorneys, prosecutors, public defenders, county council, or other government actors later enforce or rely on the order? Were you threatened, removed, arrested, financially penalized, denied review, forced into programs, restricted in movement, separated from your children, or retaliated against after objecting? This report is not a court judgment. It is a public alert. But if even a fraction of the allegations are substantiated, Riverside County may be facing one of the most significant court-centered corruption scandals in modern California history. In addition to prior noted efforts to investigate, review, and preserve records, affected individuals should specifically look for language stating, parties stipulate, stipulate to commissioner, deemed to have stipulated, temporary judge, commissioner, or judge pro tem. Compare those records against what actually happened in court. The defining question is no longer whether courthouse paperwork looks official. The question is whether the authority behind that paperwork was lawfully obtained. If it was not, and if officials knew, continued, concealed, enforced, and retaliated, then Riverside County may not be dealing with procedural defects. It may be dealing with a criminal syndicate operating behind the seal of government. This report is not legal advice. It is a public alert. Review your records. Compare the procedures to the governing law. Do not simply dismiss these allegations. Investigate them and seek competent legal counsel, because many potentially affected individuals may still be unaware these issues exist. Viewers are encouraged to preserve, repost, and share this report with others who may currently be involved in Riverside County proceedings, or who may have been impacted in the past. This is episode 2. The next report is titled, Syndicate Cover-Up and Whistleblower Retaliation. That report will examine the notice trail, named actors, retribution, and conduct Blacklight says establishes intentional cover-up of a criminal enterprise. It will address alleged willful disregard after formal notice, alleged reckless indifference to mounting damages, and alleged retaliation used to further or conceal the asserted machinery. Episode 3 will also show how the public, media, and higher authorities may directly observe and obtain significant evidence supporting the alleged continuation of the described enterprise. For additional information and supporting materials, visit blacklightadvocate.com. Review the material under the Operation ENC tab, including the report titled Operation Emperor's New Clothes. If you are a whistleblower or victim, or if you have further information concerning this matter or associated actors, contact Blacklight Advocate at contact@blacklightadvocate.com. Requests for confidentiality will be respected.